sir.
Sure, Sakti Pandey sir, are you available?
Sir, yes, sir. Sir, will join within 2 to 3 minutes, sir.
Okay, sir. Okay, sir. Please contact all the HODs and
Yes, sir. Yes, sir.
ask the people to join me immediately.
Yes, sir. Sir, please welcome, sir. Hello, sir. Welcome, sir, for the seminar.
Welcome, sir. Sakti sir. Sir has arrived.
Yes, sir. Yes, sir. Sorry, sir. Welcome, sir.
So, welcome, sir.
Sir, we are unable to hear your voice, sir.
Are you able to hear me now?
Yes, sir. Yes, now I can hear. Yes, sir.
Sir, good morning and welcome to our institution programs, Praveen. That's sir. As a principal, I'm very happy to invite you. Sir.
Thank you.
Sir.
Yeah. Yes.
Sir, if joined in start, sir.
Still joining, sir. Even we are giving also, sir.
Maybe we can wait for 5 minutes or so.
Just we can. What about ED, sir?
Sir, I think that is. I invited. He is in other activity. I think, sir. He may be there in a meeting, sir.
Okay.
Hi, Shakti.
Nursing principal, ma'am. Good morning, ma'am.
Good morning, sir.
Good morning. Welcome, ma'am. Welcome.
Sir, shall we start, sir?
Yeah.
Sir, please, sir.
Success is not a key to happiness. Happiness is a key to success. If you love what you are doing, you will be successful. A pleasant morning to one and all present here. I take the golden opportunity to welcome the Honorable Chief Guest, respected Executive Director and Deputy Director of SRM Trichy Campus, beloved Principal and Vice Principal, Head of various departments, and friendly faculty member of SRM TRPEC Engineering College, and skilled participant from different colleges for the today's faculty development program. Welcome you, sirs and madam. The greatest gift you can give someone is your time. So, thanks for spending your valuable time with us. On behalf of whole SRM TRP family, I welcome you all to this special occasion. Now I call upon Akalya of first year EC department to give a brief detail about IPR.
A wonderful morning, everyone. I once again welcome all the dignitaries who were present in this great event. We all have assembled here to converse about intellectual property rights. Intellectual property rights are legal rights that provide creators protection for original works, inventions, or the appearance of products, artistic works, scientific development, and so on. The significance of intellectual property can be traced to the ancient use of stamps on bricks by Roman brick makers for the purpose of identification. It is a product of human intellect, and the rights granted on it allow its owner to benefit from the fruits of this intellectual endeavor by creating a monopoly over it. Such benefit is not always a natural right, but requires recognition. The crucial when IPRs are executive and therefore they always a challenge to strike a balance between the interest of innovators and the interest of society at large. An important factor is having an adequate legal framework to protect the interests of innovators and inspire confidence that their intellectual property will be protected, in turn triggering further innovation. IPR litigation in India is quite diverse, owing to the large number of courts, varying degree of experience of the judicial officers in IPR matters, and varying manners of practice. As a result, some courts have become preferred forums over others. In India, intellectual property rights recognized under Statute are the Patents Act 1970, the Trademarks Act 1999, the Copyright Act 1957, the Designs Act 2000, the Geographical Indication of Goods Act 1999, the Semiconductor Integrated Circuit Layout Design Act 2000, the Biological Diversity Act 2002, and the Protection of Plant Varieties and Farmers' Right Act 2001. Thank you all. I hope I have given some gist of this great event. Thank you.
Thank you, Akalya. A smile is a universal welcome. Welcoming everyone is art and our culture. Now I call upon Dr. K. Shakti Pandi, Associate Professor, Department of Physics, to welcome the gathering.
Feeling the presence of the God Almighty in heart and mind, I am extremely happy to welcome you all for this gathering. I welcome our Honorable Chairman Dr. R. Sivakumar Sir, MD PhD, SRM Group of Institution, Ramapuram, Madhavalani and Trichy Campus. Welcome, sir. In the same line, I welcome our Honorable Executive Director Dr. S. Subhadi Sir and respected Deputy Director Dr. N. Balasubramanian, SRM Trichy Campus. Welcome, sirs. I extend my warm welcome to our experienced person, Dr. R.S. Praveen Raj, Principal Scientist, CSRNist, Ministry of Science and Technology, IPR Advisor to Government of India. Welcome you, sir. I welcome our beloved principal who has supported all the ways for the successful conduction of this program by initiating the research culture. I welcome all the administrative heads of our SRM group, SRH campus. Welcome our vice principal, HODs, and beloved colleagues, professors, research scholars, industry persons, ladies and gentlemen from our college and other institutions. A warm good morning to one and all who has gathered here virtually. Once again, it is a great pleasure in welcoming you all in this FDP on research planning and business development using IPR, organized by the SRM TRD. This FDP on IPR rights is arranged to give the better understanding on the rights over the creation and how it will be used for the business development. Our resource person, Dr. R.S. Praveen Raj, Principal Scientist, who is an apt person for this program as a speaker. We would like to take this opportunity to express our sincere gratitude to our resource person for accepting our invitation without any hesitation. We truly appreciate his dedication. Thank you, sir. We hope that this FDP results with the valuable takeaway to all the participants. Once again, on behalf of SRM Trichy campus and the organizing team, I express my warm welcome to all. Thank you.
Thank you, sir. Now I welcome our principal of SRM TRP Engineering College, Dr. P. Ganesh Babu, to talk few words.
A very good morning, one and all present here. Our beloved Chairman, Sir, Dr. R. Sivakumar, our Executive Director and Deputy Director of this Trichy SRM Trichy campus, and it is my pleasure to invite for this program Dr. R.S. Praveen Raj, Principal Scientist, CSIR NIIST, and also I must extend my thanks for him to readily accept his presence for this particular FDP. He is an eminent personality for giving in this particular topic about the business development using IPR. So it's a good opportunity for all of us to have such an eminent personality here. We must utilize this. And it is time to invite for this program our Principal Nursing College, my dear professors, those who are all participating in this from all over India, and my dear colleagues for arranging this particular excellent program for the development of faculty members as well as research aspirants. And research is a culture. In the welcome address, our Professor Shakti Pandi mentioned that about the word that is research culture. Research culture is a very important thing for in India, particularly in technical higher educations. The research culture is must among the faculty members first, then among the students also. Then only the innovative projects for the purpose of society. Ultimately, all these research must reach the society for the common man. So in this aim, we need to do a lot of planning to develop this culture. And after this innovation, how we can get the IPR? That knowledge of IPR still, there is a lack now in India about the knowledge of IPR. Then how we can utilize for that business? Again, we are in India, we are lagging. We have wonderful innovations in our country from ancient days, but we failed for to get the IPR, and again we failed for making it to business. So in this aspect, all of us can develop this particular culture, and we are waiting for hearing the words from the experts in this particular area from IP Management and Technology Transfer, Ministry of Science and Technology, Kerala. And one more thing, when we are talking about the research culture, and many times faculty, as a faculty members or as a innovators, we are not able to make it as a proper planning. So that planning is very, very important, because when we are starting that innovative work from the inception till the end of outcome, that is product. If we make any innovative product, till then we have to plan it, because many of the research work are breaking in between, or sometimes it may not be getting the proper outcome. So for that, the problem is the planning. When we are making the culture, the planning is the first step for that research culture. So that also is included in this FDP program. I must thank for the organizers of our colleague professors. They made a wonderful job and organized this function. It is a function, they have planned for many of the programs like this. It is a one among them. I wish all the best for all the researchers for developing our indigenous research culture with IPR awareness. Wish you all the best. Thank you. Thank you, one and all present here.
Thank you, sir. Now I call upon Madhumita to preamble about our chief guest. Madhumita.
A positive morning to everyone. The chief guest, Dr. R.S. Praveen Raj, Principal Scientist, CSIR, Thiruvananthapuram. He hails from Anand Panchayat in Thiruvananthapuram district of Kerala state, India. He has done his schooling and college at Thiruvananthapuram. He holds a postgraduate degree, M.Tech, in Power Systems Engineering from University of Kerala, and then started his career as an electrical and electronics engineer and changed to R&D management profession later. Worked closely with Government of Kerala is devising IPR policy of Kerala of 2008, which addresses the concerns on traditional knowledge protection. Inspired and guided Dr. Sashi Tharoor, MP, to introduce protection of traditional knowledge in Indian Parliament, which was tabled in Lok Sabha. Functioning as a member of Advisory Committee on Intellectual Property Rights, apprenticed Power Systems Management and Supervision in Vikram Sarabhai Space Center, Thiruvananthapuram, for 1 year before joining patent office. Worked as electrical engineer supervisor training in a private firm in Trivandrum for 1 year. Had delivered many invited lectures on IPR, Right to Information Act, human resource development, and technology transfer in many parts of the country. Have been associated in the process of making IPR compulsory in the curriculum of university, school education in Kerala, syllabus design, and setting up of institutions. Member of the team which devised in the IPR curriculum of PG Diploma of National Academy of Agriculture Research, Hyderabad and Indian Council of Agriculture Research Laboratory. Was invited to attend a discussion meeting on science innovation and discussion policy of South Asian Association of Regional Countries and Indian National Science Academy, New Delhi. Member of Patent Cell in the Directorate of Ayurveda Medical under Health and Family Welfare Department, Government of Kerala. This is the right time to invite our chief guest to deliver the address in the field of technology transfer, patent mapping in the vast manner. He is not only a scientist, eminent research scholar in various fields of patent technology and forecasting in patent research. In turn, he has doing continuous process in past decades in paper publications of traditional knowledge docketing system, geographical indications, inventive step, or non-obviousness of an invention. He has done immense working towards and delivered in conference and seminar proceeding. In particular, the first is patent, ban or boom. Second one is India moving to a strong patent regime, challenges and concerns. Third one, how to draft the patent specification. And the fourth one is traditional medicines and intellectual property issues. Fifth one is not but least IP laws in Indian agriculture. Moreover, he lectures in and visually published as videos. Success is not a destination or a one-time event. It's an evolution and infinity process for development. Before concluding, I thank our respected principals, faculty members, staffs, and as well my friends indeed. Once again, I welcome you all for the enlightening session. Let me invite Dr. R.S. Praveen Raj, Principal Scientist, to convey his wisdom with us. Please welcome you, sir.
Thank you, Madhumita, for your introduction. And before starting it, okay, I'm seeing now that this sharing the screen is enabled. It was not enabled till now. And first of all, let me thank Shakti Pandi in advance for inviting me to this program. I met him only 1 year back, and we had a nice trip to Madurai, to the college where he was working earlier. And maybe now he feels that I'm the right person to talk on the subject. Anyway, thanks for this invitation. And though many of you hinted about IPR, I in fact like the note presented by Agalya. I don't know whether Agalya has done it herself or somebody else has done for her to present it. Even though the note has so many confusions in between, and many clarity issues and errors also, but the summarizing was excellent. So congratulations to Agalya for that excellent note on or introductory note on IPR. And now let me now come into the topic. this topic is not on basis of intellectual property rights. I don't know, Thangapandi has asked me to talk on this advanced topic. So it is, I presume that most of the people have some exposure to intellectual property rights. Anyway, I have included a few slides on basics of patents and copyright, because for researchers, it is on intellectual property rights, mostly is copyright and patents. And the other things, the relevance of topic I want to say in the beginning itself. You know, many of the universities, foreign universities, especially in UK, USA, etc., they're also transferring technologies, and that translation process is not so easy. So if you go to any universities like Harvard and all, there will be a list of like their professors who have won Nobel Prize. That itself is a long list. But in our university, there may be one or none. And there will be another list of technologies transferred by them. The companies, the startups or the companies started from that, spinned off from that university and became global companies. All these things you can see there. But as of now, India is not prepared, not approved to be of such a status. Any of the universities, even IITs, are not able to deliver to the extent which we are focusing on. So this presentation, I am aiming at enabling the universities to develop IP, transfer it, or develop technology, transfer it, and then prosper and ensure that those companies are becoming a profitable listed companies in future. So we will see how many entrepreneurs will be coming up, technology entrepreneurs will be coming up from among you. So again, one more thing I want to point out, your principal was saying that if such a thing has to happen, there has to be tremendous planning. So such tremendous planning has to happen. So that I will tell you in the slides how that planning has to happen in realizing the technology entrepreneurship or technology business. So now let me go to the slides now. Let me have your feedback. Are the slides visible to you?
Sir, it is visible, sir.
So now all of you, please mute your mic. Okay. So I'm starting the presentation. So I'm starting from the fundamental concepts of legal concepts of intellectual property rights. Say, what is property rights? That is what we need to discuss first. If you look at, I mean, the one question I was used to ask the people wherever I go for a lecture is, in Indian Constitution, we say fundamental rights. So what do you mean by fundamental rights? Fundamental rights are those rights which I can enjoy parallelly with others. When I enjoy my fundamental rights, others are not in a position, others are also in a position to enjoy those rights. That's called fundamental rights. So apart from that, across the world, the property rights are also recognized. The relevance of property rights is that property rights are exclusive. That means I have the exclusive right to enjoy my property. If somebody else wants to enjoy that property, he needs to have permission. Or if I have a property, if I have some land, if someone wants to enter my land, they need my permission. But however, if a policeman wants to enter, if you do a crime, that is permitted. That's different. But normally, if a property, if somebody has to encroach upon, or if somebody has to enter your property, they need your permission. This exclusivity is with you. That is the property rights. So property rights can be divided into primarily two, tangible and intangible rights. These tangible rights are which you can touch and feel. Like that is divided into movable and immovable. Your table, scooter, etc. are movable property rights. You can take anywhere where you want. And always the properties are purchased from somebody, or you manufactured by yourself, or you own by some other source. That becomes your ownership. And some immovable property. Immovable property means your land, your house, etc. So these are all tangible property. This is a property which we usually see. Apart from that, there is something called intangible property, which you cannot touch and feel. At the same time, that is inside your brain. So that is called intellectual property. That is intellectual property, and intellectual property rights are differentiated in the next slide. So there is something called intellectual property which you can touch and feel, but intellectual property get embodied into a article which is tangible. So when you make an invention is incorporated into some object, and finally that object you can touch and feel. So that is the difference between a tangible and intangible property. So what is intellectual property? Intellectual property is that which results from the creations of intellect in industrial, scientific, literary, or artistic field. So that is the definition of intellectual property. I am differentiating between intellectual property and intellectual property rights. Many people are confused between what is intellectual property and what is intellectual property rights. So intellectual property is that which results from the creations of intellect. So if you are intellect, then your brain creates something in the field of industrial, scientific, literary, or artistic. So what is intellectual property rights? So intellectual property rights are rights granted to own the intellectual property. So the definition is, this is why I was mentioning, your introductory mark by Agalya was saying something confusing about intellectual property rights. So this is the definition of intellectual property rights. Intellectual property right is a legally enforceable exclusive right. So every word is relevant. Intellectual property is legally enforceable. Intellectual property right, you can go to the court and enforce it. It is exclusive because all the property rights are exclusive. So intellectual property rights are also exclusive, and it is granted. That is also important. Unlike the other property rights, this is granted by government, and granted to whom? To the owner of intellectual property. Who is owning the intellectual property is being granted the intellectual property rights. And again, I want to say the owner need not essentially be the creator. The creator can give his intellectual property to somebody for a money or a sum, and then that person will become the owner. So intellectual property rights are granted to the owner of intellectual property and not exactly to the creator, and for a limited period. It is for a limited period. All intellectual property rights are supposed to be for a limited period. Say for example, copyright, it is for a period of 60, lifetime of the author plus 60 years. In the case of patents, it's 20 years. Maybe in some other case like trademark, geographic indications are perpetual. There it is beyond this period. So there are reasons. I don't mean, according to me, trademark and geographic indications are not even intellectual property rights. But anyway, now these are included in the folder of intellectual property rights. We need to study like that. So again, as I already said, intellectual property rights are the rights created on the property. So you can assign it to somebody or license to somebody. So what is the difference between license and assigning? Licensing is like leasing a property. Suppose you have got some land, you can lease to somebody for taking the its profit for some time by them for a sum. You'll take some money and give your land where maybe some crops available, and they will take the benefit for a few number of years. That's called leasing. At the same time, assigning means selling. If you're selling a property, that is called assigning. So if you're selling intellectual property, it's called assigning. If you're leasing your intellectual property, it's called licensing. So I'm just classifying all the intellectual property rights. The first classification is copyright and related rights, and the second classification is industrial property rights. The examples of industrial property rights are patents, rights on designs or designs act, trademark, plan builders right, geographic indications, trade secrets, IC layout and design. There are like some 7-8 intellectual property rights available. There may be plenty coming in the future also. Anyway, in this presentation, I am concentrating only on patents and copyright. And what is a copyright? A copyright is an exclusive right granted to the owner of a literary, artistic, or scientific work to use or authorize others to use it for its reproduction, public performance, translation, adaptation. So copyright is also an exclusive right, as I said, because it's a property right, it's also intellectual property right. And it is again granted to the owner of a literary, if you have a literary, artistic, or scientific work. So copyrights are granted on works. What kind of works? Literary, artistic, or scientific. The rights given are to use it by himself or to authorize others to use it. So practically how it is acting is, if somebody is not taking your permission to copy it, that's a violation of copyright. So that is why there is copyright piracy and all we are saying, CD piracy and all. It can be prosecuted under Copyright Act. So why is then it is for reproduction? It can be for reproduction, it can be for public performance of the work, can be for translation, can be for adaptation. Adaptation in the sense if you have a drama adapted from a novel like that. So if you have a novel, that novel can be adapted into a drama. So this is an example, literary field, artistic field, dramatic field, sound recording, musical recording, cinematography, etc. Copyright laws offer a protection to the expression of thought based on some idea. So if you have an idea, no idea can be protected by any of the kind of intellectual property right. There is no patent for an idea. There cannot be any copyright protection for an idea. So what is being protected under copyright is expression of thought. That means if you are seeing a sunset and if you are making your picture, if you are drawing a picture, that is a copyright because it's a work. So based on the idea, expression of thought. Similarly, if somebody is writing a poem after seeing sunset, that is another expression of the thought or expression of the idea. So that is another work protected. So this is there's no idea which can be protected. And it provides a bundle of economic rights to the owner of the copyright and also a bit of moral rights. So these are the rights which we notice listed here as economic rights, the rights of reproduction. Your right to reproduce, make as many copies, right of adaptation and translation. If you want to translate from one language to another language, and from adaptation, from making a drama out of cinema or drama out of a book, and right of distribution, your right to distribute the copies, right of public performance, right of broadcasting, etc. And say, for example, if you have copyright on a work, and you can give these economic rights to different persons, so giving to a single person. All the right can be assigned to a single person also. You can license it to people, you can also assign to somebody. Say again, I want to say a point, you're all researchers. In India and also abroad, whenever you are sending your paper for publication in those journals, you're also giving an endorsement without knowing what is written there. That says that the copyright is subjected to and entirely assigned to that journal. And then that journal you are purchasing here. By paying money. This is something very horrible actually. So we are doing it. Why we are doing it? Because we want to get high impact, we want to publish in high impact factor journals. So only because of that we are surrendering our copyright rights, and just for that benefits, again we are buying it. We are not giving it free for your university or research institute. This is just for understanding. And then moral rights. Moral rights are those rights where the author has certain rights, even though your economic rights are solved. They are called moral rights. So, for example, when I have written a poem or I have written a book, even though I sell all my rights, I have the right to be known as the author. That author's name cannot be replaced. That is one moral right. Second thing is, nobody can mutilate my work. Even though my work is assigned to another person for a money, the content of the work cannot be mutilated by anybody. So that's the second moral right. These are two important moral rights. And coming to copyright again, copyright protects, and I'm setting a platform for you at the end of this presentation. If you have any doubt on copyright which you are facing, you can ask me. Copyright protects all types of original literary, artistic and scientific works, published or not. Whether published or not, that is an important point. Even without publishing also, copyright is valid. That is why there are some people who were not used to publish something, but they want to have the right of copyright. I mean, their work. So some people are used to do something like this. They were used to send their own work in a post office box in other place to their own post office. Say, for example, if I am staying in a village in Kerala, I will be sending my work in a post cover to my own address in Kerala, and when it is brought to my house, I can keep it without opening the seal. So that means tomorrow, if there is a need of a proof, that will serve as a proof. But now that is not required, because if you submit your application to Copyright Office, they will immediately register it. So you will get a protection like that. So what I want to say is, copyright protects all type of work, even though it is published or not. So it has to be original work. That is the only condition. If it is a copy from somebody, tomorrow somebody can take you to court if it is copied. If it is original work, there is no issue. So copyright is there in literary works, musical works, dramatic works, pictorial, graphics, sculptural works, motion pictures, and other audio-visual works, sound recordings, pantomimes, and other choreographic works, architectural works, software and multimedia productions, etc. I am just saying about the impact of copyright. Some of things are very relevant for you also. The copyright is not territorial. That means if you take a copyright in India, that is valid all over the world according to Berne Convention. There is a convention called Berne Convention. At the same time, if you take a patent in India, that is only valid within the boundaries of India. That is called territorial. That is for protecting the sovereignty of the country. So in this, we cannot allow some other country to grant a patent in India because patent is having a lot of impact. That when it comes to my next slides, you will understand how dangerous, how useful is patent. So copyright is not territorial, as I said. So if you just file a copyright application in India, you will get protection all over the world. So copyright does not prevent individuals to make single copies of work for the private, personal, and non-commercial purposes. Suppose if you want to make single copies of the work for a private purpose, for example, if you're making one or two copy of the pages for your own study purposes from the book, that is not a violation of copyright. If you share with one or two friends also, that is okay if you're not taking the money. Or if a teacher gives to all the students in the class a few pages of a book, then that is not violation of copyright. At the same time, if you are making multiple copies of the entire book and selling in the market, that is of course the violation of copyright. You might have heard of a Delhi copyright case recently, might be some 3-4 years back. There one photocopying fellow in front of Delhi University. He was making study materials according to the syllabus by copying relevant topics from different books, and hence when we started getting a good sales volume, then the publishers sued him in Delhi High Court. But finally, the court came out with the verdict. That is an important, interesting thing. He did not violate the copyright of a particular book per se. His intention was good. He was only charging the actual expenses of the photocopying only. So that was considered as fair use. So what I'm saying is that courts can decide according to the situation. So the court need not always go after the copyright owner's interest, especially the copyright owners of big corporates. A government will be, the court will be taking a stand in the interest of the common man. Again, another one. In order to reproduce and publish a translation or adaptation, authorization must be obtained from the owner of the copyright of the original work. Suppose there is a book in Malayalam or in Tamil, and there is also that is translated from say English. And the Tamil book you want to make a film, then you should be taking a permission from the author of the Tamil book and also the original author of the English book from which it was translated. Then copyright offers protection for a minimum period of lifetime of the author plus 50 years in almost all the countries. In India, copyright offers a protection for the minimum period of lifetime of the author plus 60 years in India. Not minimum, it's the maximum itself. Lifetime of the author plus 60 years. That means, I'll explain. See, for example, Mahatma Gandhi has written many books. And but now, as of now, all the books of Mahatma Gandhi is out of copyright protection. Because I'll explain, 1948, Mahatma Gandhi was assassinated. So according to the principle of copyright, this copyright is valid for lifetime of the author plus 60 years. So in the throughout the lifetime, author can enjoy the rights plus 60 years. And 1948 plus 60 years is 2008. So the books, all the copyright of the books authored by Mahatma Gandhi ended in 2008. So this is how we are calculating it. So until now, there were a foundation which was enjoying the copyright of Mahatma Gandhi's books. So now the books will become cheaper once the copyright is gone. So both civil and criminal remedies are available against infringement of piracy. It's also an important point. In the case of patents and all, if there is any infringement, then only civil remedy is available. That means you have to go to the civil court and get the remedy for that. In the case of copyright, criminal remedies are available. That means police persons can take action against you. You could be behind the bar if you are infringing the copyright. Copyright ownership. Author is the first owner of a copyright in a work, always. In the case of a literary dramatic work, it is the author, the person who creates the work. In the case of a musical worker, it is the composer. In the case of a cinematographic film, it's the producer. In the case of a sound recording, it's a producer. In the case of a photograph, it's a photographer. Again, not the person for pose for the photo. If you pose for a photo, again the copyright go to photographer. Otherwise, you have to get an agreement with him that you are purchasing the right of the photograph also. Then it's fine. Otherwise, it's the photographer. In the case of a computer generated work, it is actually the person who has coded. It is the person who has caused it to code, who had funded the research. So again, there is, in the list you can see that there is no copyright for the singer. A singer can get the copyright only if singer also becomes a producer. So that is why Yeshudas in Kerala or MS Balasubramaniam or whoever it may be, if they get royalty because they happen to be the producer also, they co-produce. That is why they get a right. Singer, when they get the payment, their role is over. So then again, there is something called joint authorship, etc., etc. And copyright protection in India is for the lifetime of the author plus 60 years for literary work. It is 60 years from the date of registration for a cinematography or sound recording. And broadcasters' right of performance right is for 25 years. So anyway, these things we are not going into details because I didn't cover the broadcasters' right and all. Coming to patent, this is, as I said, this is the most important, most relevant, most dangerous thing among the intellectual property. This should be harnessed properly. Otherwise, it is dangerous. So what is a patent? Patent is an exclusive right to prevent third parties from making, using, offering for sale, selling, or importing the patented product. So I again said it's an exclusive right. That also started in the very beginning. Patent is also an exclusive right, just like any other property rights and IPR. And again, if you see that the right is not even a positive right. It's a right to prevent third parties. So not practicing something, not for selling something, it is to prevent selling of something. That is the power the patent is holding. So exclusive right to prevent the third parties from making. Who is third party? We will see. First party is the government who is granting the patent. Second party is the patentee who is getting the patent. Third party is anybody who is not authorized by the patentee from making it, using it, selling it. Again, there is the word offering for sale. Even though you are not selling, if you are putting it in a shelf for selling, if you are stocking the product for selling, that is also an infringement of patent. So patent is very powerful. And again, on importing the patented product, even for importing something to India, a patentee can prevent it. That is where it is becoming much, much powerful. So that is why you might have heard of Basmati issue, which rocked the Indian Parliament long years. And somebody had to take a patent in the US for something else which is not Basmati. And only thing is that that particular patent also was speaking about long grain and aromatic smell of Basmati. But why India had to oppose it in the US? Because if that patent claim saying about long grain and aromatic smell of Basmati is not revoked, Indians will not be in a position to import the genuine Basmati to that country. Exporting the genuine Basmati to that country. That import they can prevent. US can prevent the import of that to that country. So that is why the importing becomes so powerful. And then who is granting a patent? Patent is granted by government within this territory. That is why patents are granted by the government with this territory. Government also has the power to cancel a patent if it becomes dangerous to the country. That is why patentee cannot prevent the government also. and for a limited period of time. The limited period of time is called 20 years, and that is for the commercial exploitation of the invention. So that is granted only for the commercial exploitation for the invention to the fullest extent, not for enjoying any monopoly. See, I'll tell you what's the relevance of a patent. Suppose patents are not there, industrial revolution will not happen. If you're having a most advanced mobile nowadays. If patent systems were not there, when some kind of mobile or something was introduced in the market, it is easy for others to copy it. So since there is a patent protection, people are afraid to copy it. So the other company will go and tell their research and development team a new product is coming to the market that is technologically advanced and is cheap. So you need to do better research and come out with a product that is much cheaper and much technologically advantageous. So the second company will come out to such a product. So the first company will lose the market now. Even though they had an advanced product, the second company product much advanced product, they will lose the market. And second company would have already taken a patent for their invention. So that they again go and tell the first company that a better production has come into the market, and then you need to make another better product. So I have set the scenario of two companies competing. So there are at least 10,000 companies in the market, manufacturers of mobile. So they will do wonders. That is why we are having a mobile now which is more than a computer now. So this is made possible because the industrial revolution is made possible because of the patent. So in effect, nobody is going to enjoy the 20 years of monopoly. That again want to refer to the initial notes made by Agelia. So she said that the patent systems are not only for the economic benefits, but also for societal benefits. So this what is patent is it is made as a tool for the societal benefit, made for the society, not really for others to make money. And in consideration of the full disclosure of its invention through patent office. So if they have to get a patent, what they have to do is they have to disclose the invention through the patent office. If you publish it anywhere before filing a patent application, novelty is lost. So patent cannot be granted. You have to first disclose to the patent office, and patent office will publish it after 18 months, and they will also grant you a patent. An invention means a new and useful solution involving an inventor. What is invention? Invention has to be new. It has to have a novelty, and should be a solution involving an inventive step to a technical problem in an industry. If there's a technical problem existing, you are addressing the problem. The solution to the industrial problem is what we call as invention. That has to be new. It should have an inventive step. What is inventive step? I'll say in the next slide. So patent is an award for the inventor because the inventor gets a name and fame as an inventor, and the person who is investing money gets assured returns. That is why patent becomes an important tool. If this patent kind of exclusivity is not there, nobody is going to invest in your invention. What is patentable? Only inventions are patentable, I said in the beginning. So what is an invention? Invention means a new product or process involving an inventive step and capable of industrial application. Where inventive step means a feature that makes the invention not obvious to a person skilled in the art. That means it should not be a mere workshop improvement. There shall be an invention in the inventive steps as well. That is called inventive step. And capable of industrial application means in relation to invention, that invention is capable of being made or used in the industry. You should be able to use the invention in the industry. So, so I think it's clear what is inventive step. Say for example, I'll put an example. Since most of you are either physics or electronics background, suppose there is a TV and radio put together in a single box. Radio is something which can work independently. TV is something which can work independently. That means, so how will you do that? Simply you will draw a wire inside. Maybe you will put an SMPS. Then split two SMPS and split for giving power supply to radio and the television. And then finally both will work independently. This may be new. but there is no novelty in its doing each one. There is no novelty in the steps. So that is why it's lacking inventive step. Okay, and now there are certain inventions not patentable in India. First one, invention lacking novelty, inventive step. Of course, it cannot be granted a patent. Invention which is contrary to well-established natural laws. Even invention is against the natural laws. So, for example, E is equal to mc square. We know that it's already something established. Some theory is established. Or say somebody is bringing an invention which says a perpetual machine, a machine which will run infinitely without giving any energy input. So such kind of thing, it's against the well-established natural law. If somebody says that an anti-gravity machine, that's against Newton's principles. So that kind of inventions will be summarily rejected by the patent office right away. The invention is contrary to public order and morality. Anything which is against the public order will not be granted a patent. Say, for example, like someone is inventing a letter bomb. Letter bomb also can be a wonderful invention, of course. But a letter bomb cannot be given a patent because it's against the public interest, public order. If it's a mere discovery, I said invention only can be patented. If something is a mere discovery of mixing something together also, it cannot be granted a patent. Mere new use of a non-substance, some substance is already known, you are simply finding out that can be used for some purpose without experimentation and all, so that cannot be granted a patent. At the same time, if you do its XRD, its NMR studies, all those things, and if you say that this has got a value on something, that kind of research background, if you are saying a new use, that is eligible for a patent. Methods of agriculture and horticulture are not allowed in India for patent. Then any process for the medicinal, surgical, curative, prophylactic, diagnostic, or therapeutic or other treatment of human beings or animals are not allowed to patent in India, because if they're allowed to be patented, a doctor taking exclusive right on that will not allow others to practice it. So that will be against public interest. Then plants or animals as such or their parts cannot be granted a patent, but other than microorganisms are allowed to be patentable, provided that such microorganisms are new. That means microorganisms are genetically modified organisms. Genetically modified or genetically engineered microorganisms alone are allowed to be patented. Software per se, mathematical model, business model, algorithm, etc. cannot be allowed to be patented. At the same time, softwares, embedded softwares could be allowed to be patented, because that one will give a result. Or otherwise, if there is a hardware and software, and the hardware cannot work without the help of the software, and the software is an embedded chip, then probably that could be granted a patent. Works which can be protected by any other IPR will not be allowed to be protected under Patent Act. That is also understood. Traditional knowledge, if something is non-traditionally, like use of manual, use of turmeric, that kind of things will not be granted a patent. There are many such history cases, and there are certain inventions related to atomic energy which are not allowed to be patented. And this is how it goes. When you submit a document, a techno-legal document called complete specification to patent office, which satisfies novelty, inventive step, and industrial applicability, government is giving an exclusive right. So that exclusive right is what you are going to enjoy for 20 years if patent is granted. So power of patent is an example. It will be interesting. Mostly in many classes I usually say patent is a barking dog. Mostly patent is a barking dog. It won't bite, but it is having sharp teeth. And if it bites, it's very dangerous. That is why people are afraid of patent. Ordinarily, we are not. But the companies in their fray are afraid of the patents. It's an example of Polaroid versus Kodak. Polaroid and Kodak both are camera manufacturers. So instant camera was one invention brought in 1960 by Polaroid. They have taken some 12-15 patents also on that. Then Kodak started, then after some time, Kodak started developing on technology. You have to remember, even though the invention was that of the Polaroid, Kodak started developing on technology. They developed the technology by themselves independently to beat Polaroid's patents, and they introduced their own version of the instant camera thereafter. Then what Polaroid did was, Polaroid went to the market, purchased a few copies of that camera, disassembled it, and they found that it is the same invention, though the technology was independently developed. So Polaroid sued against Kodak. They went to the court and sued against Kodak. And then finally the judgment came, whatever profit they have made, profit Kodak had made, had to be given to Polaroid. It amounted to $1 billion. And again, they said patent is for 20 years. So only 5 years is over. Next 15 years, Mr. Kodak stay out of this market. So this is why the patent is such a powerful thing. And now we are coming to the real business. So I have set the standard because some of you were not much aware of what is the copyright and patent. That is why I have taken this much time. So now we are coming to the business opportunities of an R&D institute or university. So as I said, if you have an intellectual property in the beginning, whether it's already filed, protected or not, even without that, without filing a patent application also, it's called IP. And what are the options available for an R&D institute? The first option is you can sell the IP. So sell IP and forget it. That means you don't do anything with the IP. That means it's assigning the IP. So what's the advantage of an institution like if you do like that? You will get immediate cash. You don't have to put any money further for any research that is gone out of your hand. You will get the money, forget it. And then what is your loss? Suppose if you had a high potential, then no upsides. You cannot do anything. Even if you want to do something with that later, the person who has purchased from you will stop you. Okay, that may also block your future FTO, your freedom to operate. That's something called freedom to operate. I'll explain to you very clearly. Okay, and the others can also block your freedom to operate. I mean, your freedom to operate could be compromised since you're selling it. Then the question comes, then where we can do it? You can do it in non-core areas. You should be doing it in the fringes areas of your research work. If you don't ever sell an IP in your core area. And next is contract research. That our organizations are doing it all the time. So what is a contract research? That means you're telling a private company, you give money, we'll undertake a work for you, and we'll give you the results. And there, what are the advantages and disadvantages? What's the pros? You can learn about the customers and markets. You may be entering into an area where you never had a research till now. It's a low risk thing when you are entering it. The cons, the disadvantages. The customers takes a major value. You have to give know-how developed to them. Sometimes they may also ask for the IP ownership. So where the IP scope will become limited. So the advantage which you are having is you are entering into a new area of research, a facility, and the core competence leveraged. Your core competency will be leveraged further. Another option is joint development with a private company. There, your share, the pros, advantages is that if you want to develop it by your own, you have to put a lot of money into that business that you may not have. So you need to share the risk with another person. So that money is brought in by the company, you are sharing the risk. It is complementary. So your company are doing it complementary. More resources are available. And since the private company is involved, private company knows you're in a position to market it faster. And then reduce the upsides. You can see that the upsides, the opportunities are reduced because you are tied up with the company. And then the risk of litigation in case of failure is also there. The company has given a lot of money, and if you could not deliver the results you are expecting, there is always a kind of litigation. So what you have to do in such cases, you should be finding also very strong marketing partner having a technology gap. If the person is really in need of a technology, then you can take such a person on the board. So these problems will go away. And this IP synergy is coming because since he knows the market, we are in a position to go in synergistic with the work. And then come into licensing of technology. That is an area where a lot of money can be availed by research organization. But again, for research organization to license a technology, you have to go a long way by investing a lot of money. So where the advantages are multiple applications, values maximization, the low asset risk. If you are not giving it exclusively to somebody, there is an opportunity for getting more money in future. And exclusivity risks are always there because somebody may ask for exclusivity, which is then which area, for what duration, in which segment you are asking. All these questions are very important. And then in such cases, what you have to do is the partner has the capability across value chain, except the specific technology. Then we need to really analyze the client and take that. I will be explaining in the coming slides. Then another option is spin-off or incubation. So spin-off is, suppose you have got a technology you have developed, and with the technology, if you are able to make a company from your own organization, is called spin-off. I don't know whether it's clear. I'm just making it very clear. Suppose if you have developed a technology, with the technology, if the research organization or university itself could make a company which grows and becomes a big company, that's called spin-off. It spins off. So you should spin first before spinning off. That's all. So the advantage is that whether inventors are prepared to do that. And the disadvantage is that the need for non-technical capabilities. With just the technical capabilities, the research abilities are not sufficient for making a spin-off. You should know beyond. It's a high-value niche area creation. So incubation is another thing. You are setting up an incubation facility within your campus, where in a particular area of technology, you have all the facilities. Then if an entrepreneur comes with an idea, we'll help them out to grow as a company, and we should help them in all the areas. Now, other possibilities for revenue to a research organizations are consultancy projects, where you may be giving advisory consultancy, where you'll be purely using your expertise. Maybe some consultancy project will also result in IP. Your organization can give training. Organization can get money on using analytical instruments in the case of testing and all. So these are all the areas. In fact, all the areas I have said. These are the areas in which a research organization can make business. And now I'm coming to the core area. Since IP is a topic, what is IP management? IP management includes the following things. Securing an IP asset. First of all, you need to get the intellectual property rights. That means filing a patent, etc., etc. So once you get it, or before even getting it, you need to document it. Then you need to docket it. Docketing in the sense, documenting is different, docketing is different. So with whom the particular document is available, if you made a bibliographic information, that is called docketing. And finally, the commercializing of the IP assets. And there should be an IPR cell in all the research organizations. It can be IPR, technology transfer, business development cell. And the role of such a cell is, so before taking up a contract R&D consultancy project, I already mentioned all the kind of projects in the previous slide. Sponsored project, collaborative project, or it's the grant-in-aid project. Grant-in-aid project comes from Government of India kind of sources, where you just have to give a report at the end and make as many publications. That's called grant-in-aid project. But whenever there is a client involved, then it is a real business, risk is involved. And then in such cases, you need to do the negotiation with the client. You have to make an agreement for consultancy, sponsored project, or collaborative research. There has to be a secrecy agreement sometimes, because some people may not be ready to reveal what is in their mind and company. For a joint collaboration, maybe that is needed. You may have to enter into secrecy agreement. Sometimes it has to be a material transfer agreement if some material is to be transferred. It can be biological material, it can be other chemicals, whatever it may be. Then if there is sensitive security involved with the foreign collaboration, then there should be clearance from line ministry. Then recording for future reference. All these things should be done with your IPR cell. And before starting the research, what you need to contact the IPR cell for guidance. Without contacting the IPR cell for guidance, don't ever make a commitment with anybody outside, especially for IP, and that will be very, very dangerous for you. And then state-of-the-art search has to be done. You need to do a search regarding whether the invention is already there in the public by somebody invented it. If it's already there in the invented, then you need not have to repeat it. So there's no reinventing of wheel. Why should wheel is already invented? Why do you want to reinvent the wheel? And now comes the question of maintenance of project records. Even some of the well-established laboratories are not following this. So what you have to do, when you are starting a project, you need to maintain a project records. By project leader, it is regarding the initiation of idea, list of innovators and principal contributors, responsibilities and extent of participation in each individual, significant contribution by each, then project completion report signed by each of the investigator, certified expenditure for each project activity, and by each investigator, there shall be a record book maintained. In addition to the record book maintained by project leader, every investigator shall maintain a record book regarding her joining the project, extent of participation, work is verified by the project leader and or by the director. Then only the inventorship can be allowed. So this is based on this only we are deciding who is the inventor. And the maintenance of lab record, every investigator, including project leader and not excluding research scholars and project staff, maintain a proper record of a day-to-day experiments or research in a standard format, reflecting the major breakthroughs or revolutions. The data works has to be recorded by each investigator and certified by the project leader. And finally, there has to be an audit for this intellectual property. IP audit has to be conducted by the organizations. Either first internally and at least once in a year by external person. So there is a crucial point at which the IP protection has to be taken. IP protection can be applied before also, but if you are not taking the IP protection at this crucial point, that is very risky. The crucial point is here. You have an idea, and from the idea stage, it's a high risk on control whether to proceed with the idea or not. But at the same time, cost is very low. So you will get a feasibility area, and after the feasibility area, the development starts. So then you reach a major point of decision because the cost is going to escalate, the risk is going to come down. If you are not taking up patent, at least at this point of time, nobody is going to invest in your pilot plant, semi-commercial, commercial trials, etc. It is better if you protect your IP when the very beginning itself. When the inventor feels that invention has evolved, that means say you like a car, you need to contact the IPR cell. So IPR cell will help you with invention disclosure form. You disclose invention to the IPR cell. They will sit with you, and after discussion jointly, you will again do a novelty search because you need to ensure that your invention is again novel, because somebody parallelly might have done an invention like this in the world and it's already published. Then again, you need not to go for a patent application. And after that, after assessing the patentability, this IPR cell will tell you on whether to publish it or patent it. The guidelines for drafting will be given by them. So again, what is novelty of invention? Again, it's important. Novel invention is one which has not been disclosed in the prior art, where prior art means everything that has been published, presented, or otherwise disclosed to the public on the date of patent. So everything which is disclosed in the public is called prior art in any language. And if your invention is there in the prior art, then you are not eligible to get a patent. That's the simplest definition. At the same time, again, you need to check whether your invention is having an inventive step. So I already explained by an example of this television and radio put together. Another example, if you put in, you might have seen this. This walking stick carried by some people that can be disassembled, mechanically glued again. Okay. At the same time, there are also somebody has been inventing, say, a lamp post. The advantage is again portable. They can mechanically glue it, unglue it, and take it anywhere, disassemble it back. So the advantage is only portability. So technically, there's no novelty. Even though novelty is there, there's no novelty technically. So novelty even step is not there. And so how the patent application has to be submitted. The patent application has to be filled. You have to draft the patent application. You have to fill the forms. There has to be assignment or endorsement. Either the inventors can sign the form 1 for filing in India, otherwise they can make it in a stamp paper, ₹100 stamp paper, that you're giving all the rights to the organization. inventors are supposed to give rights to the organization completely, because if you are working on a project funded by the organization or externally funded organization which has been brought to the organization. Then this is the contents of a form 1. Name of the applicant should be there, address should be there, nationality, name of inventors and their address and nationality, address of service in India, where you are going to file, all those things should be there. There is something called provisional specification or complete. So if your invention is not complete, you can file a provisional specification and you will get 12 months time for filing the complete specification. Provisional specification is not legal, it's only technical. Unless you are filing a complete specification, you will not get the advantage of priority date. This is how the provisional specification front page looks like. There you have to put the title and it says the following specification describes the nature of this invention. And if it is a complete specification, it has to particularly describe the nature of the invention. You have to write the claims also. If there is no claims, it cannot be called as complete specification. So generally, this is the contents of a complete specification. If you are writing an patent application, these things should be there. A title, field of the invention, state of the art in the field, summary of the invention, object of the invention, statement of the invention, details of the invention, scope and ambit of the invention, claims, abstract. Anyway, I am not going into the details of it because this itself is a 1.5 hours presentation, specific complete specification. At the same time, I want to tell you what is claims. Claims are that part of the complete specification which gives a legal protection for the invention. They define a boundary, just like you are seeing in the title deed documents in your home, where your boundaries of your property is defined by the property of others. Here you are defining with this, for example, an apparatus for catching mice, comprising a base member for placement on a flat surface, a spring member, etc., etc. All the parts you have to list. If it is a chemical for cleaning windows, which comprises of 10 to 15% ammonia, maybe second, maybe 5% some other substance, just like that. Another example, since most of you are from physics, ECE, etc. It's a data input device comprising an input surface adapted to be locally exposed to a pressure force. A sensor means disposed below input surface for detecting the position of the pressure or pressure force on the input surface, and outputting an output signal representing the set position, and evaluating means for evaluating the output. I'll give 1 minute. Can any of you say what it is described in this? Since it's an electrical electronics case, I'm putting it. Can any of you say, those who want to say can unmute the mic and say, what is this? What is described here? What electronic component is disclosed here? Please. Please read it and say what electronic component is worded in English like this. Shakib Pandi?
Sir, yes, sir.
Sir, this is Joseph. Tell me, sir.
No. Can anybody say what is the electronic component described here? Okay, what's the transducer?
Can act as a transmitter and receiver. It's a transducer.
What's the transducer?
Act as a both role. Yeah, transducer. Act as a transmitter and receiver. The both work using a transducer. We can send for ultrasonic sound waves. For this transducer, we can send the sound waves and then we can get the from the reflection from the sound waves also receive.
No, let me say, a transducer is something which converts a physical input to electrical input.
Yes.
That is the simplest definition. Am I right?
Okay.
So this is a pressure transducer. If you read it, when a pressure is applied on an upper surface, that is being sensed by the surface below that, and then that is converted to a legal position. That is written here, right? Now everybody can read it. A data input device comprising an input surface adapted to be locally exposed to a pressure or pressure force. A sensor means disposed below the input surface for detecting the position of the pressure or pressure force on the input surface, and for outputting an output signal representing that position, and an evaluating means for evaluating the output signal of the sensor means. Is it clear now? So this is a pressure transducer. So this is the way you should be writing the claims. Why? Because you are, if you say pressure transducer, an engineer can understand, but a judge cannot understand it. So you are making it easy for a judge. I don't know whether we are making it complex for an engineer or a scientist. So this is the legal language. Okay. So please mute your mic again, all of you. So this is how the figure looks like. Your application number, applicant name has to be on the top. Then the total number of pages of figures and number of the particular figure has to be the right side, and bottom side the applicant or the attorney has to sign. Anyway, that I have just said about the contents of complete specification. Other responsibilities of IPR is you have to continuously monitor patent office publication and other publications. You have to do renewal of patents, licensing and commercialization of patents and know-how has to be done. Litigation has to be done in connection with the infringement if there is any litigation comes. Then agreement or licensing the IP or know-how has to be done. And inventors shall not be allowed to commit license of know-how or IP to clients without knowledge of IPR, since because it involves a lot of legal complications. And then now we are coming to IP evaluation, then technology evaluation. So each word is relevant. So no need to put. I'll be will not be putting too much time here because it's a bit complex. IP evaluation is just for checking whether IP has value. In the sense, IP evaluation is only saying not the conduct. It's a qualitative analysis of whether IP is worth something or it is useless. So that's called IP evaluation. I'm just differentiating IP evaluation and IP evaluation. IP evaluation is to check not for a quantitative purpose, but for a qualitative purpose to check whether that IP is worth or not. So the first thing to do is a legal search, whether patent has been granted or not. Granted patent is still in force. Whether patent has been granted, the term of the patent. Then if there is any amendments to the claims, ownership of patent, qualitative analysis has to be done in the IP evaluation. Then freedom to operate search has to be conducted to check whether you are in a position to research on something, whether you are in a position to transfer a technology, whether you are infringing the patent of somebody else. That is called freedom to operate searches. And also when your technology is ready, you need to make a technology readiness level. Technology readiness level is followed all over the world. It comes from TRL 1 to TRL 9, from basic technologies to technology ready for launching in the market. Okay. Again, coming to technology evaluation is also like this. We again checking whether technology is worth, whether it's valuable in the market. That is market demand, business opportunity, revenue potential, time for commercialization leader, market entry barriers, cost advantage, geographical market reach, regulatory acceptability. All this qualitative analysis is called technology evaluation. And now comes what is valuation of IP or technology. It's a cost approach. That means you need to identify the value of the intellectual property so that you can sell to somebody else. So how do you identify? So it's a very difficult process. There are different methods like comparable approach, cost approach, income approach, etc. In the comparable market approach, we have to really identify the market value of an IP. That is, it's not at all easy. So in our laboratory and all, what we follow is called direct method or cost approach. What we do is we do a real expenditure analysis. How much money we have already spent on developing the IP or technology, and then based on that, whether that money can be realized by licensing it. Plus, we'll assume an amount which can extra get from the market by negotiation. That's the easiest approach we can make. So I'm only saying about the evaluation of direct method here. So cost of the development you have to calculate. You have to include cost of securing the IPR, that means getting the patent, etc. Cost of maintaining the IPR, that means the license fee. the renewal fee. Then laboratory overheads, notional amortization of staff, equipment, facilities deployed for developing the IP, opportunity cost we may get from the client. So then that is how we are deciding on the IP. And the technology pricing, again, you have to have many factors like technology pricing is license specific. It's not like IPR valuation. So again, it depends on how many licenses you may get. Based on that, you need to do a pricing and which territory, what is the duration of exclusivity, application of exclusivity, minimum royalty clause to be included. So there are so many complex parameters included in a technology pricing. So this is the costing of technology in a direct method I have put it. And translational research is something very important. This is a project for a translational research. When we see that there is an opportunity occurring at some point of time, there is an opportunity, but you may perceive it only after some time. You may not come to know in the very beginning that an opportunity is perceived. So the moment you are perceiving an opportunity, you start going for the project. The project will be formulated here. After formulating the project, you are defining the project, putting in money, all this till then product is realized for production, it's a negative flow of money. And only when it comes into launch, there will be starting a positive cash flow. After the first customer is satisfied, it's the innovation cycle time. And after which you go to the second one, and also positive cash flow also starts. Whatever money you are incurred should be adjusted here. Then whatever money you received after that is called profit. And after some time, definitely the project will become extinct. Project will not have any value. This will be stopped. So this is how translation research project works. And technology transfer, the definition of technology transfer, it is an application of technology for a new use or new user. It is a process by which technology developed for one purpose is employed either in a different application or by a new user. The activity principally involves increased utilization of the existing science or technology base in new areas of application as opposed to its expansion by means of further research and this is the standard well-known definition of technology transfer. To be very simply, if you say, if you have developed a know-how and if you are the set of know-how, if you are transferring to somebody, either exclusively or non-exclusively for development of a product. So when you transfer technology, you should give all the supporting documents in the technology transfer. That's called technology transfer. So here the receiver purchases the right to utilize the technology. It may be outright purchase or payment of an initial lump sum and royalty. That means they can pay the entire money in the beginning itself, or they can pay part of the money in ransom and remaining money in the royalty of the sales. And again, you can see that in every commercial technology, there is a value of death. If you are not in a position to commercialize the technology at the time you are looking at, that means after technology transfer, your research is done, your development is done, technology is developed and technology transfer you have done. Until then, it's negative flow. Even after technology transfer, the person who is taking it is putting in money. If it is not success as a product at this point, that means that's the value of death. If it takes more time, nobody will be ready to put in more money after this point. Otherwise, when you recover the money you already invested, that will become a success as a business. Then there are many types of licenses. One is exclusive license. That means there can be only one licensee. Even the person who is licensing it, that means licensor loses the right. That's called exclusive right. But in the case of sole licensing, it's exclusive, but for the licensor. The licensor still retains the right, the sole licensing. In the case of non-exclusive, you are licensed to any number of people. There can be irrevocable or revocable licenses. You can say the condition. There can be territory. Some can be within one country, can be within a state, within a particular district. Territory you can define. And which area, field of use, which area you are allowing them to market the product, etc. Then whether we are allowing them to sub-license. Normally when we license in our organization, we do not allow the licenses to sub-license. they have to, any other person has to come and get license from us. Cross licensing sometimes, because both the companies will have some technologies and they may have to cross license each other. So commercialization strategy for technology is including technology factors, intellectual property factors, market factors, availability of funds, finance, etc. Say, for example, intellectual property factors to be considered in a technology transfer are patents, whether in India and other countries, design registrations there, copyrights are there, support to prosecute the infringement, whether we are ready to provide support to infringe the prosecutors at any time, or whether there is any confidential information involved along with that, etc. Then, coming to market-related factors, it's the market and business potential factors, status of competing technologies based on patent search, patent mapping, market servers, business intelligence, techno-economic evaluation, etc. The type of application, whether it's for single or multiple industry users, size and value of the market, Indian or foreign, market entry barriers, socio-economic indexes, all these things you need to look into. Then finance-related matters, you need to have a project developmental cost, you need to work it out. Then whether it's break-even and availability of technology funds for the licensing from the market, whether it's equity based, whether somebody is ready to put in money, whether they may ask for an equity. The banks, technology development agencies, government promoted schemes, venture capitalists are available, service and facilities for incubation, etc. Assessing the licensing. So whether that is the most important thing. Before we transfer technology, we have to assess the licensing. Because if the first license is a failure, then the second license may not even go. So technology transfer will become failure. So high credibility in business of the license is important. So morality of obeying the contracts and relevant laws and regulation. Whether he is sincere, reliable, rational and cooperative company. Good reputation in the related industry. Sound financial status of the company. High level of managerial and technical capabilities, adequate facilities, equipment and machinery, capability to understand, absorb and promote the technology, strong and active marketing department do they have, all these things are relevant. So technology transfers are not happening to the extent, especially in India. The reasons are low technology transfer levels. Technologies are not completely ready for a commercial launch, maybe in some period in between. Lack of funding for scale-up and pilot scale studies. Limited commercial prototypes for market validation and field testing. Lack of market research studies. Lack of techno-economic feasibility reports. Limited access to risk capital. Inadequate lack of IPR protection. Higher technology transfer costs, etc. So this is a complete picture of how technology transfer licenses and agreements are done. You can have a look at it, then I explain. So the invention is, once there is an invention, that we will be patenting, and after which it is commercialized. And commercialization is coming like this. We can do various ways. It can be assignment. Patent can be assigned. There can be joint ventures with some other party. There can be licensing. So licensing can be voluntary licenses or non-voluntary licenses as asked by government. In the case of voluntary license, it is cross-licensing, sole licensing, exclusive licensing, non-exclusive licensing is already explained by me. And then there has to be an agreement. Agreement has to be in writing, registration has to be there, royalty payment clause extra has to be put, and then the non-voluntary licenses are as per requirement of the government. So I'm just putting all those possibilities. This is the content of a draft license agreement. The name of the party is licensed property. What is the kind of licensed property we have to say? The type of licenses, which is the area of licensing, territory of licensing, term of license agreement, improvement, then royalty clauses, termination clauses, government laws, obligation of licensor, obligation of licensee, product liability, IP licenses, all these things you have to put very clearly in a licensing agreement. And coming to business incubation, business incubation is something, as I already mentioned, it is where nowadays there are a lot of funding available from central government and other sources. If colleges and universities can put it up, it's nice. So there you should have that sufficient capability to take up when somebody comes with an idea, from the ideation level to launch of the company it goes, finally to graduation. So at every stages you should be in a position to help them. It goes like this. When a company is coming with an idea in an incubator, they have some founders of the idea. So they'll be putting some money here, the founders. So that they call it as a startup. So once it reaches a pilot stage, you need to have some funding. Then you'll go for the funding from angel investors. So angel investors are not so greedy people. So they will be putting the money for a purpose. They may not even ask for an equity in the company. Some people may ask for an equity also. The equity can be given for against the money they put. But after which it reach a stage of called rollout. In the case of rollout, you will get venture capitalist funds. The venture capitalist funds will be putting the money definitely for an equity share, and also they may take a return also. They want a return. Angel investors are ready to suffer, but venture capitalists are not ready for that. And after which the growth starts from here, then you may get financing from banks. So after expansion, you may go for IPO or acquisition. IPO is the initial public offering. You are putting, your company will be listed, your shares can be sold. That's called IPO, or you can be acquired by another company. That's called acquisition. So that there it attains a maturity. So this is how a company is incubated and attaining the maturity. So finally, the question is, can I invent? Yes, anyone can invent, solve a technical problem in the industry. The inventing, the ingenuity can be learned and get trained up. Simplicity is no bar for patenting. Even if your invention is so small, if it satisfies novelty, inventive step, and industrial applicability, you can get a patent on that. So some of the examples I have, two examples I have put on, I already explained. For instance of transportation, you are making a grooving and ungrooving mechanism. Similarly, in the case of suppose if there is a restriction happening in the elbow of a pipe, the best thing to do to improve the flowability is to make it into segments. That is the picture, you can see that. Making something into segments will increase the flowability, more flow. So this kind of, all these are inventions. So if you invent what to do is, don't publish anywhere before filing patent application. You should file provisional or complete specification with the application. Check for technical or commercial viability. If you feel that there is a technical or commercial viability, after complete development, you have to file a request for examination. That's within 48 months. You can get a patent, you can commercialize it, make profit. Feel to us. You have to also check whether somebody is infringing your patent. If somebody is infringing, then you need to use the legal tools, sue them. So there are wonderful careers in intellectual property rights, and IPR managers, those who are managing the intellectual. The IPR management technology transfer I do together. Technology transfer experts, examiners of patents and design, patent and trademark attorneys, etc. The good careers, and definitely highly paid careers, competitive careers. And finally, our IP matters for you because money matters for you. Absolutely, no doubt. Everybody wants money. So IP can make you rich. Thank you. Any questions?
Sir, I am Morgan, sir. I have a question, sir. Can I ask,
please.
sir?
Yeah.
Sir, under patents rights, can we completely transfer the ownership to the other, sir? Not, sir.
That is called assigning.
No, ownership, sir, completely.
Yeah, that
Complete ownership will be given to them.
That is called assignment. That process is called assignment, outright sale of the patent. That is called assignment. Completely transfer to others. Even before filing patent also you can do that. Transfer your IP. Is it clear?
Yes, sir. Yes, sir. Thank you, sir. Thank you, sir. Can I ask one more question, sir, regarding that COVID-19 vaccination? Because in India, a lot of many COVID vaccination medicines are using, sir. All the medicines are already got the vaccine, got the patent rights or not, sir?
I think
how they are using it?
No, complete. Usually for getting a patent, it took minimum of say minimum 3 years, 2 years, or India 7 years. Okay. So what happened is this vaccines are developed very recently, within last 1 year. You are all aware. So now US has already taken a policy that there is no need to give any patent for such vaccines. Since vaccines are not developed in US, at present the question does not arise in India. In India also, if it comes, we will take a policy that it will not be under patent because then the vaccines will become more costlier. So this is not likely to be under patent. It's okay?
Okay, sir. Okay, sir. Thank you, sir. Thank you, sir.
Dear participants, any other questions? Any other questions, dear participants? Yes, sir, madam. Yeah. Any other clarifications, sir? Okay, sir. I think no more questions from the participants, right?
Sir, can I ask, sir?
Yeah, please.
Yeah, yes, sir.
Sir,
Yes, sir.
suppose during the, this is the question, sir, during that 60 years of the tenure for the patents rights, sir, for using the patents right. So during the 60 years, suppose in case of death, it should go to the legal head, sir.
No,
royalty or using anything.
No. First of all, 60 years protection is not there for patent.
So, as per mentioned,
copyright.
Yes, sir. Yes, sir.
Lifetime of the plus 60 years.
Okay, sir.
Then what?
20 years.
20 years. Okay. Then you know the question. What's the question?
During the tenure, sir, in case of any death occurs, that patents rights, the legal heir of the patents rights, you should go to the others, no, sir. Is it possible to go to the legal heirs? Legal heirs, sir. Legal heirs.
Just like any other property, if someone dies, the rights will go to the legal heir. Even while patent is not granted, the other person can join as a. Suppose if you have filed a patent application, the patent is not granted, then your son or daughter can help the patent office to include him as a copy. So when patent is granted, he can be patent.
Okay, sir. Thank you, sir. Thank you very much. Sir. Thank you, sir. Okay, sir.
Dear participants, any other questions, sir? Yeah, okay, sir. Thank you for your questions. So now I request Professor Purushothaman to deliver the vote of thanks. Purushothaman sir,
Okay, sir. Right.
please.
Good afternoon. On behalf of our SRM TRPEC Engineering College, it's my privilege to propose a vote of thanks at this juncture. First of all, I thank our management for providing constant support to organize this event. I would like to express my gratitude to our Honorable Chief Guest, Dr. R.S. Praveen Raj, to take out time from his busy schedule to grace this FDP event. I express my sincere thanks to our Executive Directors and Deputy Director of SRM Group, Trichy Campus, for their support towards this occasion. I extend my heartfelt thanks to our beloved Principal and Vice Principal for their constant support throughout this event. I would like to extend my sincere thanks to the participants and research scholars of various institutions for participating in this FDP program. I thank all the HODs and faculty of SRM TRPEC Engineering College for their valuable contributions in all our efforts. Finally, I extend my thanks to our organizing team who have worked hard to make this event become a successful one. Once again, I thank you all for making this program as a grand success. Thank you.
Thank you, sir.
Sir, thank you, sir.
Sir? Yes, thank you, sir. Thank you so much, sir. Thank you so much for spending your valuable time with us, sir. And you gave some impact your mind regarding innovation. Show the participants have some knowledge from it. So we hope soon we will be with our pattern. Thanks for your wonderful timing, sir. Dear participant, and thank for participation and actively participated, and thank for questions. Thank you, Satyapandian sir, for encouraging us to organize this wonderful FDP. So to the management and my colleague, my dear students. Thank you, sir. Thank you all once again.
Thank you.
Thank you.
Participant, the feedback link posted, so you can check the chat box. So after completion of our feedback, you can get your certificate. If any issue, please please message me or call me. And in WhatsApp group also, you can intimate your issues. Okay. Thank you, participants.
Sir, thank you, sir. Once again. Sir.
சொல்லுங்க ஜி. போட்டேனே, இங்க பாருங்க, யூடியூப்ல தான் போயிட்டு இருக்கீங்க, இங்க பாருங்க. இல்லையே, நல்லா பாருங்க ஜி, நான் போஸ்ட் பண்ணிட்டேன் பாருங்க, எவ்வளவு போயிட்டு இருக்கேன். அதுவா? இல்லையா, அவங்க என்ன சொல்லி ஃபீட்பேக் தான் போட்டிருக்காங்களே, அதான் போட்டாச்சே. இல்ல, என்னோடது காட்டுதல் இல்லையா உங்களுக்கு? பாருங்க, என் பேர் காட்டுதல் இல்லையா உங்களுக்கு? நான் போட்டிருக்கேன் பாருங்க, போஸ்ட் பண்ணிட்டே இருக்கு, நான் அப்படியே காட்ட மாட்டேங்குது உங்களுக்கு நெட் இல்லையோ? சரி இருங்க, அப்ப உங்களுக்கு நான் மெசேஜ் போட்டுமா? போட்டீங்களா? சரி, அந்த லிங்கான்னு செக் பண்ண சொல்றீங்க, இருங்க நான் பாத்துக்கிறேன்.